Thank you. I think we'd like to explore just one other aspect of this, and that's the interaction between major strategic policy making at cabinet level, prime ministerial level indeed, and the folding into that of key legal advice. We're not going to go over the ground we've already covered earlier today, but there is a set of questions we'd just like to pursue, and starting with you, Usha.
Thank you, Chairman. We discussed with Lord Goldsmith, the process through which he was involved in this decision-making process, and what became very clear that during the time, particularly before July 2002, ministers were making public statements. I think he had to write to Mr. Hoon, and he saw a memo of the comments that Mr. Straw had made to Colin Powell, and he was having to constantly write and tell them, they should be seeking his legal advice. Do you think the fact that he had to respond to people making statements without being clear about what the legal situation was, do you think that could have been avoided if the attorney had been able to discuss issues in the cabinet, and that would have actually ensured that the formal advice of the attorney would have been preempted?
I think the very first paper we got on this back in March, or the clutch of papers we got in March 2002, which was seen obviously by Jack. I mean, the legal paper was provided by Jack Straw's department and by Jeff Hoon as well, was, I think, fully aware of all this. I mean, people had the basic legal framework. Now, I think it's perfectly good for Peter Goldsmith as the Attorney General on his own volition. If he thought someone was saying something that couldn't be justified or was unwise in legal terms, he got on the phone and said, don't do it, or wrote them a note and said, come back into line on this, which I think they did. I don't think it would have made a great deal of difference to have had him there at Cabinet. What he needed to be able to do was be in a position, feeling sufficiently confident, which he did, to be able to intervene and say, I don't agree. But
the impression we got that he was constantly having to ask and want to write his opinion and provide his opinion, and he said it wasn't always welcome.
Well, I think he said that about the particular opinion he gave at the end of July. And it wasn't so much, as I said earlier, that it wasn't welcome. It was, I was dealing with already a difficult situation. Now I had another issue to take account of. I had to take account of it rightly. And incidentally, he was completely right to do it, because it made a big difference to the way we approached 1441 and the resolution there. But I don't think it would have made it... Look, I'm very happy to talk about how, for example, you might do some of these things differently now, but I honestly don't think having Peter at the Cabinet meeting would have made a difference. What did make a difference was his having the confidence to be able to say, as he should as an independent attorney, as it were, for the government, to pick up the phone and, even to the Prime Minister, which he did, say, this is what you can say and this is what you can't.
But that doesn't allow for a collective decision-making where there's a proper consideration of different options and so on.
Well, I think in respect of the legal opinion, Baroness, I think the key thing really was this. The Cabinet weren't interested in becoming part of the legal debate. They just wanted to know, is the Attorney General saying it is lawful or it's not? I think in respect of these other issues, there were actual debates about this. I mean, there was a debate, for example, in January 2003, if I recollect it. There was not just about the diplomatic issues, but specifically on the humanitarian and aftermath questions in Cabinet.
But going back to the legal advice, I mean, when the Cabinet met on the 17th of March, I think Lord Goldsmith presented the draft parliamentary question answer, but there was no discussion on this legal advice. And we've seen the report of a discussion that he had with Mr. Straw on the 13th of March, in which he was persuaded not to present a finely balanced paper of the arguments, but to actually, present this paper, which was going to be his parliamentary question. And I think Claire Short made it clear that she wanted to discuss it and know whether the Attorney General had changed his mind, but no such discussion took place.
Well, the whole purpose of having, I think Andrew Turnbull explained this to you, the whole purpose of having the Attorney there at the Cabinet was so that he could answer anyone's questions about it.
But the Attorney General did say that legal basis is essential but not sufficient. So in that sense, the broader implications of invasion, I mean, should that not have been discussed?
The broader implications in terms of whether it was right or wrong to do it. Well, I mean, that was, in a sense, the purpose of the cabinet discussion, I think. And, you know, it's perfectly, the legal issues were one aspect of this. But I think once the members of the cabinet, I mean, the members of the cabinet were really focused on the politics. And indeed, even Robin Cook, his attitude was, if you get a second resolution, then I'm with you. But if you can't, then politically, I think this is too difficult. So, you know, we were very focused on those political as well as legal questions.
But would they not have allowed them to weigh up the risks for themselves, for the civil servants, and so on? I mean, you know.
Well, I think they were weighing the risks up for the country, but I don't think, in respect of the law, as it were, I don't think members of the cabinet wanted to have a debate with. I mean, Peter was there and could have answered any questions they had, but their basic question to him was, is there a proper legal base for this or not? And his answer was yes. Now, we actually said, and this is the reason why we had Peter there, and I think in any future situation it's sensible to have the attorney there, but we offered, in a sense, we offered him up. He was the lawyer there to talk about it.
Mr. Blair, do you think there is a contrast of approach between what frequently happens in government at all levels, including to the top, that in forming policy you engage with legal advice because it may need expression in statute or comply with existing bodies of law. You fold in the legal advice through the policy-making process. That's one approach. The other is to set very clearly what your policy objectives are, and they may be, as in the Iraq case, high and strategic objectives. And then, as it were, work around or through and with the constraints and opportunities that legal advice then gives. Do you see a difference of approach there?
I think that there could be, but I would say in this situation, since in a way March 2002 was the time when you set the first framework for this, the legal advice was one of the key things we asked for, and we got it. And that legal advice, and it's interesting to go back and look at it, it was legal advice that was saying you needed a fresh resolution. And one of the reasons why we went down the path was to give a fresh resolution. One of the things, and this was part of the debate that happened later, was I felt, well, we got the fresh resolution, so why is there still a legal problem? But then I was told what the problem was.
It still seems, from all we've heard both today and from previous witnesses, that there was a very clear strategic policy objective set for Iraq, which was to bring about compliance with United Nations resolutions, disarmament, including of WMDs, and if that meant regime change by military means, that was the last resort, but not ruled out. But there were moments very, very late in January, February, March 2003, when that policy objective could have been blocked by a failure because of a legal constraint. Is that unavoidable in situations like this?
Well, I think it's unavoidable in a situation where it's that controversial and divisive, and it's that, you know, that open to challenge. You see, there actually could have been a major debate about Kosovo and legality. There could have been. There wasn't, because in the end most people went along with the action. They agreed with what we were doing. The truth is that the law and the politics follow each other quite closely.
Yes.
And I think necessarily in this situation where we were setting our strategic objectives, you know, we had this strong belief, and as I say, this is my belief now too, that this threat had to be dealt with a certain amount of urgency. So, and we had our alliance with the United States of America and so on, and all the issues to do with Saddam. And then obviously at the same time, as you're proceeding and strategy is evolving, diplomacy is evolving, you're looking at the issues to do with legality.